Good afternoon. We can do better now. I know y'all are ate and you're full and all that good stuff, but we're here to have a very informative session. We welcome Delta Sigma Theta Sorority Incorporated. Our speaker for the day is Soror Rochelle Connolly, attorney Rochelle Connolly. She's going to bring us some valuable information, things that we should know or need to know in regards to estate planning, wills and trusts. And so after we render a word of prayer, I present to you, to some, introduce to others, Soror Attorney Rochelle Connolly. Please bow your heads for a word of prayer. Father God, we come to you this afternoon, thanking you for this day. Thanking you for allowing us to gather here to learn valuable information about how to plan for our families in time of our transitions. Lord, we ask that this is that the information that you bring before us or to us is used for the betterment of our people. Lord, we ask that after this meeting, that the refreshments that have been made may it be used for nourishment of our body. In your Son Jesus' name we pray. Amen. Soror Connolly.
Good afternoon, everyone. I am so happy to be with you here today, and I would like to thank Pastor Ford and his congregation, as well as the members of Delta Sigma Theta Sorority Incorporated, for sponsoring this workshop here today. And so, what I always tell everyone when we talk about it is a heavy subject. And since it's a heavy subject, we're just all going to be cousins. We're all cousins. We're all friends, okay? And so, as they're pulling up my presentation, I just want you to take this opportunity to think about your family and think about the legacy that you would like to leave for your family members, and that you want to have ownership of that. You do not want a man or a lady in a black robe telling you how to distribute everything that you work so hard for. Or you don't want, if you're not in your right mind, a man or a lady in a black robe saying where you get to live, how your property is distributed, who gets what. So allows you to take ownership of everything that you have, that you've worked hard for, that your parents worked hard for, the legacy that you would like to leave for your family members. So it allows you to make a plan. So, nobody likes to think about a time that they will not be here. But we know transitions happen. So, what I want you to do after you leave here today, you're welcome to take pictures of any of the slides that you see here today. If you have questions and they are general in nature, I will have different times where we can stop and we can ask questions. If they're general, if they are specific to you, my grandmama left some land, blah, 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 come and see me afterward. And so hopefully I will be able to get you to the right person that you need. So just a little bit about me while they're getting my first slides up. Just a little bit about me. I'm an attorney in the Huntsville area. I have been practicing a little short of 20 years. So for 15 years, I operated my own practice. I was in private practice here in Huntsville, and this was a big bulk of the business that I did. I did a lot of estate planning. So what I'm going to share with you today is everything I know from my legal research, from being in courts, the good, the bad, the ugly. So when I give you suggestions, it's not that you have to take them, but I've just seen how this plays out. In 2022, I transitioned into a role for Alabama A&M University. I've been there for 3 years, and so now I have the task of dealing with all the legal issues that happen on the university, but my heart is still in estate planning because I know that we lose a lot of property because we do not handle things accordingly. Okay, so next slide. We'll get started. Everybody ready, cousins? Okay, okay. So today we are going to talk about asset management. And so when we talk about asset management, we're talking about things that we can use that will cover our property. So we have two arms. On the first arm, we're dealing with wills, trust, durable power of attorney for business transactions. And on the other hand, we're going to deal with healthcare management. This is how you deal with issues that affect you personally. And so that includes an advanced healthcare directive, a durable power of attorney for health, as well as a living will. So most of you, when you go to the doctor or you go to have a medical procedure, how many times do they ask you, do you have a living will? Raise your hands. Every time, every time. And just by show of hands, how many of you have one? Just raise it real quick. Okay, good deal, good deal. Next slide. That's it. We ready for the next slide? Okay, here. So why is estate planning important? So the good thing is, by virtue of you being here today, you understand why estate planning is important. It allows you to determine who owns your property at your death. It avoids family disputes. You do not know how many family disputes I've had to mediate and deal with. And I tell them the same thing I told you. If you all don't come up with a decision yourself, then guess what? A man or a woman in a black robe is going to make the decision for you. And usually they do not have the same interests as me and you. And it also decreases administrative costs. And we'll talk a little bit about that. Next slide. And so it is also important that you plan for yourself. When we're thinking about planning for yourself, it ensures that your wishes will be honored. Would you want artificial food and beverage if you are no longer able to think or feel or know you're in this world? It also determines who takes care of your children. So if you have children under the age of 19, raise your hand. Children under the age of 19 in here. Okay. If you have children under the age of 19, what if something happens to you and your spouse? Who would you want to take care of them? And then who would you want to manage their finances? Sometimes you have people who are good taking care of children, but they are bad financial managers. So it allows you to decide that. And then to assess your financial needs for the future. Most of us have life insurance policies, but a lot of us do not have enough coverage, because life insurance policies are income replacement. So you want to make sure that if your spouse were to pass away, would you have enough to sustain your current level of living? So next slide. So the first thing I'm going to talk about, and you can go to the next slide, is a last will and testament. And so a lot of times when people hear this, they are intimidated by having a last will and testament, or they think, time I, sign my will, I'm going to pass away. And that just doesn't happen. But what I want for you all to do, if you don't have one, is to set a goal for making sure you have a last will and testament in place. If you are over the age of 19 and you live in the state of Alabama, you should have all of these documents that I'm going to talk to you about. You should have all of these documents in place. So I wanted to give you some key definitions that I will talk about. If you are, or if you pass away, testate is one who passes away with a will. A testator is one who creates a will. Executor or executrix, and I hear this all the time, well, I'm the executor. If you are an executor, it's a person or institution appointed in a will to carry out the terms of the will. And then a personal representative is the person who has been appointed by a court to manage an estate without a will. So I will use these terms interchangeably, but I wanted to make sure that you had a key understanding of what they mean. Next slide. So how is a will made? So in the state of Alabama, it must be written. So there are some states that will allow you to have oral wills. Not in the state of Alabama. The will must be written. It must be signed in the presence of two witnesses, and it must be notarized. So that's all you need in the state of Alabama to have a will. You can even create a will on your own. You don't need a lawyer to do it. But these are the key components that you must have in your will. Next slide. So, the benefits of having a will, again, it allows you to decide how your property is distributed if you and your spouse die. Again, I talked about it allows you to determine who takes care of your children, um, and who manages their financial assets. And if you have an incapacitated adult or incapacitated child, this is of the utmost importance because you want to make sure that they are provided for. Next slide. So here are some additional benefits. Again, it allows you to decide who will manage your estate upon death. So each of you, you may have children or family members, and you may say, hey, they're not really responsible, but I want them to be in charge of my estate at my death. This is not the time to hope that a family member or a relative will manage your estate prudently. If they don't manage their finances in a prudent manner or in a reasonable manner or in the manner in which you would, I encourage you to appoint someone else. This needs to be someone who you know will not use your estate assets for their own benefit. And it also prevents your property from being distributed through intestate succession. So when we say intestate, someone who passed away without a will. So remember I told you if you don't have a plan, someone in a robe will decide it. So the state of Alabama has a formula. If you do not have a will, they just see if you fit this formula, and they will distribute your property based upon that formula. Next slide. Okay, go to the next slide. Next slide. Okay, so again, we talked about okay, go back to that slide. I'm sorry about this. We've had to do some technical difficulties. Again, in dealing with a will, we talked about intestate succession, someone who passes away without a will. So these are my suggestions just for making sure if you have a will, things to think about when you go to see a lawyer and draft your will. If you are a member of a group, a fraternity, or sorority, designate in your will who you would like to receive your fraternity or sorority items. It may be a family member, it may be a child, but if you do not have that, designate in your will who you would like to have those items. Also, if you wish to exclude a family member in your will and it happens, write a letter dated the same date of the will that details why you are excluding that family member. So I'll give you all an example. I knew a lady, she had 3 sons, and she said, you know, she had just that one problem child. She always had to get him out of jail, pay for attorneys, and all that kind of stuff. So she said that child had gotten his inheritance during his lifetime. So she decided, she said, hey, I want to leave everything else to my older 2 sons. But what happens is if you exclude a child from a will, what do they believe? They believe you didn't love them. And so, and they also, guess what? They're going to contest that will. They're going to say, Mama was not in her right mind. Mama loved me. She would not exclude me from the will. So I always tell people, if you are going to exclude a family member, make sure you write them a letter and you explain, baby, I loved you, but you got all your money while you were living. So that's easy. If you want to leave something to a church or a foundation, tell them how you want the money to be used. You know, so hey, me, I go to Union Chapel Missionary Baptist Church. I would like these funds to be used for our academy. That's easy enough. Tell them how you want that money to be used. And lastly, you cannot leave your estate to animals. Now, I know that should be common sense, but people do it. People love their pets. And so because they love their pets, sometimes they want to leave things to them. But in the state of Alabama, you cannot do so. Okay? Let's see, next slide. Okay, so we talked about test date. I told you what you needed to draft a will. What did I say? It must be what? Written, what else? Signed, notarized, two witnesses. Okay, cousins, you all are good. Great. Okay, so we have intestate, one who passes away without a valid will. And so intestate succession is the process that the state uses to distribute property by a person who dies without a will. Remember, I told you, man or woman in a black robe, they have a formula. They're going to put your estate in that formula, and that's what they'll do. Next slide. So property will be distributed based upon state law. The decedent's estate is subject to probate administration. And in that process, it takes a very long time. We have to identify who your heirs are. And I'll be honest with you, it can be time consuming. A lot of us, we wait for several years to probate an estate, and people pass away. So if Doris were to pass away, I'm just picking on Doris because I know her. If Doris were to pass away and she had 3 children and one of her children predeceased her, but she has grandchildren, we have to detail all of those people for the court. And so on the flip side of that, when you do your will, you can list all of your family members at the time of your will. There's no dispute. When I do a will for a male, I always say this male has 3 children, and I list their names and I list their date of birth. And I say anybody else who comes up and says, hey, this is my daddy, I disinherit. And I do that because I don't want heirs just popping up and contesting the estate. So when you have a will, you can do all of that. But if you don't have a will, guess what? People will come out of the woodworks and they'll say, oh, that was my grandmother. That was my mother. That was my father. So it's better to have a plan. Next slide. So this is an example. Husband and wife have 5 children. Husband dies. How is husband's property distributed? And it is distributed. The wife inherits the first $50,000 plus half of the estate. The children receive the other half in equal portions. Now, this might not take into consideration every situation that went on in that household, but this shows you this is the formula that the state of Alabama has decided is fair. And so that is what happens when you pass away without a will. They just have a formula. They put that formula in there, and that is how your property is distributed. Next slide. So what I wanted to do, I wanted to talk about different court processes. A lot of times, and especially in the African American community, people say, oh, it's going to probate. And you don't want to be caught up in probate. And so typically what happens, people are looking for ways because they are intimidated by the probate process. So what I wanted to do for you all today is to show you the difference between the probate process if you pass away with a will as opposed to if you pass away intestate. So next slide. So if you have a last will and testament, these are the steps. The will is presented to the probate court. The probate court appoints an executor, and remember the executor is the person named in the will to administer the estate. Letters testamentary are issued by the court, and this is the official document that you can give to third parties saying, I have the authority to represent the estate. Notice of letters testamentary runs in the paper. The estate remains open for 6 months. So at a minimum, it must remain open for 6 months to give creditors an opportunity to file claims on the estate. After 6 months, bills are paid and assets are transferred to heirs, okay? So you're roughly looking at a 6 to 7 month process if everything is done correctly. Next slide. So if you pass away intestate, and what does that mean again? Without a will. Okay. So individual or an heir. So this is the difference. Anybody can petition to administer your estate if you don't have a will. It could be someone that you do not like. It can be anyone. So anyone, as long as they are an Alabama resident, can petition the court. The individual must secure a bond. And what the purpose of the bond is to say that they will not take estate assets and, steal estate assets, use estate assets for their own purpose. And I've seen that. Notice must be given to every heir. So you got to identify those heirs and you have to give notice to each one of them. Then you got to have a court hearing. The court decides to appoint a personal representative. The next slide. The personal representative must file an inventory with the court. Letters of administration are issued by the court. Notice of the administration must run in the paper. Again, it must remain open for 6 months to permit creditors to file claims. Once those bills are paid, assets transferred to heirs. And I wanted to give you those two processes because you can see the second process is longer. Would everyone agree with that? And it's more costly. And so what happens is whomever petitions the court, they don't have access generally to the deceased person's finances. So usually you have to advance a lot of these costs yourself. So you have to advance because there are filing fees and court fees associated with this. None of this is free. So generally you're going to have to go to an attorney, file the filing fees, file the court fees, the publication fees. So this takes a lot of time. So by virtue of coming today, you would know, hey, in this instance, I want to do process 1 as opposed to process 2, okay? Okay, do we have any questions? Remember, we can have general questions. Yes, ma'am. Yes and no, because you still got to identify heirs. So she's asking about survivor ownership of property. You got to identify heirs. And when I talked about in that previous slide about filing an inventory, you have to identify the property that the person owned as well. And you have to tell the court about that. So it's a lengthier process. So usually we won't get to in an administration, we won't even get to the point where someone is appointed until several months because we have to identify what property they own. We have to identify who the heirs are. We have to get those heirs served with notice of that. So it can be a very lengthy process. Like usually when people would come to see me, I had to do a chart and we had to identify all of those individuals. And what complicates this, if you had heirs that are under the age of 19, because we had to identify an adult to accept service for them because they're not in a position to accept service at that time. So I bring all of this up to say, because I want you to be knowledgeable when you go to your family reunions and say, hey, if you don't have a will, at a minimum, you need a will, at a minimum. Okay? Yes.
Hi.
Hi.
My question is, what if you don't have blood relatives? Is it okay to appoint non-blood related heirs?
Yes, you can leave your property to anyone you want to. You can designate an executor or an executrix of anyone you want to, anyone you trust. Even if you have children, you can identify someone that you trust, that you believe that would do a good job, and you can appoint them in your will.
Do they have to be over the age of 19?
Yes, over the age of 19 because they have to be an adult. And they need to be someone of sound mind. A lot of people identify institution. You know, they'll say, hey, I want a trustee to do it. I want somebody at this banking institution. So it can be a person or institution.
So if they're under 19, they will have to have a guardian
A guardian is appointed by the court. Yes. Good job. Good. You can. We'll talk about that.
What if it's not a will, but everybody's in agreement on it. Like, let's say that the spouse and then the kids are not worrying about it.
So great to have agreement when we say, but you have to go through the court process, especially if you have real estate. You have to go through the court process. It's great to have agreement, but you have to go through the court process to make it all legal. Now, there are some processes in this second process. Is if everybody's in agreement, they can speed up a lot of those processes. But you got to have you have to have a court to sanction it if you don't have a will.
But if the spouse is on the deed or on the house, then that's not a problem.
No, that's not a problem. And we'll talk about that to some alternatives, things that you can walk out of here. And tomorrow's Monday morning, you can go and do. We'll talk about that. Okay.
My question is, what happens if the surviving spouse sells the property thinking that they're the sole owner of the property, but they have children?
So let's talk about this. So everybody, if you live in a home, whether or not you're paying a mortgage, there is a deed. And I want you all to pull your deeds and to know who owns your property. If you are a husband and wife, and we'll talk about this, your deed usually has two, husband and wife, and the survivor of them. So husband passes away, and it automatically goes to the wife. You don't have to probate anything. It automatically goes to the wife. But what if husband and wife die together? That's where it gets tricky. And so you got to probate an estate. You got to identify who died first, and then you got to probate an estate. Okay? But when you leave here today, I want everybody to pull your deeds for your property and know where it is. Know where it is, okay? Okay. I'm going to take one more question. We're going to move on.
Okay.
When you're creating your will, can you list air property?
Ooh. So air property, what she asked is, when you're creating your will, can you list air property? Yes and no. So air property is property. So I'll give myself an example. I have a great grandmother who had some property in Gurley. Estate, she passed away. Estate was never probated. She had 3 children. Then 3 children passed away, but my grandmother always paid the property taxes, and she believed she owned that property because she paid the property taxes, and it goes on and on and on. So that's what air property is. And so in an air property situation, and I'm going to give you some information of some people who will help you with that, you have to identify heirs, you have to identify who predeceased whom, and actually who owns that property. So if you have an heir in air property, yes, you can put it in your will, but you can only transfer to your relatives the percentage in which you own. The problem that we have with air property is it tends to get bigger and bigger as generations pass away. So you really want to make sure that you deal with that in a timely manner. Don't just let grief overtake you handling business, because that is what I've seen. I've seen people, they, say, oh, my mom passed away and I just couldn't deal with it. So I just, paid the bills, I paid the property taxes, and I just let the house sit there. And then you pass away and your children do the same thing. You don't let grief impede your progress to handle business, okay? Okay. And we'll have time to answer some more questions. Okay, let's go to the next slide. So these are will alternatives. So my cousin over here, she asked about, what can we do if, your name is already on the deed? So we've talked about this. Go to the next slide. Okay, so we always hear about a trust. And so I am going to try to break this down as much as I can for a trust. A trust is a will alternative, and so property owned by a living revocable trust created prior to death. The terms of the trust will transfer trust property to beneficiaries named in the trust. With the trust, you must designate a trustee first. Usually, you are the trustee. You create the trust, you are the trustee. But you also must detail a secondary or an alternate trustee to manage the property upon your death. Next slide. So, the benefits of owning a trust: assets owned by the trust transferred to beneficiaries outside of the probate process. So that whole court process that I detailed for you, these assets that are owned by the trust go directly to the beneficiaries. You don't need court involvement, you don't need court intervention. If you become ill or incapacitated, the property is owned by the trust rather than a person individually. So a lot of times people become ill and you need state benefits, you need Alabama Medicaid benefits to pay for nursing home care. If the trust owns it and it's a certain time period, they can't come back and say that you own this property. The trust owns it. And the trust can remain in existence after the death of the creator. And we also call that person a settlor. So the benefit of having a trust is that it can remain perpetually as long as the purposes of that trust are being fulfilled. So I've worked on trust for several of my clients. It works really well for individuals if you say have investment property, or if you have more than one parcels of real estate. It works great for that. And this would be property outside of the home that you live in. I think a trust works great for that. If you have a lot of assets, if you have a lot of stocks and bonds and retirement accounts, I would encourage you to look at trust as a estate planning tool for you. So go to the next slide. I do want to tell you some challenges. They're not necessarily negatives, but they're challenges. The trust, not the individual, owns the property placed in the trust. So let's think about that. If you put your home in a trust, you no longer own it. So if there are any benefits, any tax benefits that you are getting from your home, you do not get that. So like if you're claiming mortgage interest on your income taxes, you can no longer do that because the trust rather than you personally owns that property. So you have to keep that in mind. Secondly, you may no longer be able to claim benefits or deductions, and you must be careful not to abuse the protections of your trust. So I had a great couple. They had gotten a trust, but they got a trust because they kept on hearing people like Susie Orman and all of these financial planners say, get a trust. But they didn't understand the management, so they were interchangeably pay bills, one time out of the trust account, one time out of their personal account. If you have a trust, generally you have a trust bank account that pays for trust assets. And then you have your personal accounts that pays for personal assets. So what happens if you do them interchangeably? If creditors come after you, they can say, hey, let me get a hold of those trust assets because you're paying them interchangeably. So you have to make sure that you segment or keep things separate if you have a trust. Okay? Yes, ma'am. Mm-hmm. Personally, you would be in the trust, because the trust at that point would be because once you have a trust, you have to claim if the trust receives any income, you have to do tax filings for that trust. So any personal benefit that you are used to receiving from those assets, if you put it in a trust, the trust owns it. And so everything related to ownership is related to the trust. So any personal benefit that you receive from property, it would then transfer to the trust instrument.
So is there a way
Okay.
when you set up your trust where
assets, I'm gonna say, are not to transfer until your death. So then you
Yes.
are responsible for paying those up until that point.
So every one of so while I say this is an alternative, all of my clients that I prepare trust instruments for, I also encourage them to have a will as well. So any assets that they did not put into the trust at their death, they could leave those assets to the trust or whomever they wanted to. So a lot of my clients, like the one I did most recently, I had to finish up some work for him. He has a trust, and he transferred a lot of his assets into the trust, but he left out his personal home because he wanted his personal home upon his death to be awarded to the trust at that time. And that way he could keep all of his personal benefits. I think he had some tax benefits that he received. He had some homestead exemptions that he received. He was able to keep all of those. And so we did it. But even if you have a trust, I'm going to encourage you to have a will as well. Yes, sir.
You all, I think you answered the question. The trust supersedes a will.
So yes, it's going to transfer outside of probate. For that will, you got to probate it.
Right.
But it transfers outside of probate. So what we're talking about now are tips and tricks to get you out of probate, things to transfer outside of the probate process.
Okay, one more question. My wife recently passed,
Yes, sir.
and I got all these death certificates, so I got to go do her business. So when I went to the bank to do her business, we had joint accounts, and so they had to have all that to take her off the account.
So let me stop you right there
Yeah.
because he's starting to give some confidential information. Yeah.
Right.
I'm going to see you after.
Right.
Okay. Okay, the guy after you.
On top of her question about rental properties, so let's say I have 10 rental properties and I put them into the trust. Where does the rent check go?
To the trust. Benefit goes to the trust. So the proceeds follow the owner. Now, you're a beneficiary under that trust, so you could say, hey, I want this trust to pay me X, Y, and Z amount a month. You can do that. But the proceeds generally need to go to the owner.
It would go to the owner of the trust. And then you would, when you pull
You
off
can
the
pay
trust,
yourself.
that's when you're paying the taxes on what you pull off
Yeah,
of it.
pull it out of the trust account.
Gotcha.
But you can pay yourself because you're the beneficiary
So-
under this trust.
So the trust is almost like you're making a twin brother.
Or a corporation for yourself. That's what I tell people. A corporation for yourself. That's what a trust is. But I think what happens is a lot of the financial planners just say, hey, get a trust, and you don't understand the management part of it. So that's why I wanted to bring up the benefits of a trust as well as the challenges that can come up so that you can weigh those when you're creating them. Okay? I got one more question. I'm going to move on.
When you create a trust, do the trustee get paid and the co-truster, do they get paid during that time frame?
So
After it's created?
initially, we're trying to say that you would be the initial trustee. So Rochelle created a trust. Rochelle is the initial trustee. So that's why I was telling him you can take distributions from your trust. You can. It's for your benefit. You can put provisions in there to pay any successor trustee. You can put provisions in there. If you're silent, if your instrument is silent to that, there's state law that says how much they can receive in compensation.
Okay, and if you put a minor beneficiary in there, can you put in there that they get a monthly fee as well?
You can.
take care-
You
okay.
can tailor it for however you want to. You can say, hey, if so long as the child is under 19, they get so much. If they go to college, they get so much. And then you can determine when they get it free and clear.
Last question.
Okay.
If you married and you created your trust after the marriage and you left that person out of the trust, but their name isn't on the deed or anything. But the deed is not in their name. You know, like they got their property, you got your property. So you decide to put your property in the trust. How does that work?
So y'all taking me too fast. But in the state of Alabama, there are provisions for omitted spouses. And so be mindful of that. There are provisions for omitted spouses. So if you find the love of your life, but maybe you all want to do some different things estate planning wise, you need to mention your spouse in those documents, and it needs to be after the date of your marriage. Because otherwise, if you do those documents and you never mention your spouse, they're going to feel that you omitted them, like it was a mistake. And guess what? They're going to give it to them. So you have to be mindful of that as well. They are. They are. They can be. Yes, sir. Okay, we're gonna move on. Y'all just took me too fast. Okay. Okay, next slide. Joint tenants. Jointly owned property by two or more people. At the death of one of the co-owners, property automatically transfers to the remaining owners. So a common example of this would be joint bank accounts. You have two or more people on that bank account. They can use it. Both of you can use it to the same extent that you can. A deed, we talked about a deed, but I'm going to talk about that a little bit more. Go to the next slide. Bank designation. So this is something that you can do from a bank designation perspective that is easy. You can go to your bank tomorrow and you can say, I want to designate a paid on death beneficiary. And so this is, they cannot have access to the money during your lifetime. Once you pass away, they go in there, they show that death certificate. Guess what? They're going to give you that check. That's easy. Everybody should have a paid on death beneficiary on their bank accounts. Okay? Okay, yes. Make sure you have POD. Sound good deal. Yes, ma'am.
So my grandmother is living with me since my grandfather passed, and she added me to her account. So is that better than a POD?
So what she said is her grandmother's been living with her, and her grandmother added her to the account. So you all are joint owners on that account. And that's not a bad thing. As people age, they may not have the mental capacity to pay bills. So you want somebody else to have access to that account. So maybe that's a good thing. I don't think it's a bad thing, especially if your grandmother has some health challenges. But before health challenges or anything else, put your other spouse or put a child on as a paid on death beneficiary. That's easy enough. That money goes outside of the probate process. Okay. Yes, ma'am. You can do more than one person. Just talk to your bank about how many people that you can designate. I don't know because it's a contractual thing. So ask your bank. Because I guess if you did not do a percentage, they would just split up the accounts and do half. Yes, ma'am.
If you've got more than one person, you have to do just like you would do life insurance.
Okay. Yeah, because it differs from bank to bank. I do know that. Yes, ma'am.
Okay, Okay, you've taken care of all the trust, the will, access, you have inherited. My question is, what is the tax access to these people? Like if I willed her my account, my house, I don't want her to have to pay half of her inheritance in taxes. So how does that work?
So that changes annually based upon the tax code. The last time I looked it up, it's a lot.
Is there any way to get around that? Because defeating the purpose if she got to pay out.
So what she's asking is what you inherited. What you inherit, does it create a taxable event? And so there is a threshold that changes it annually. And I can't remember what it was the last time I looked it up. I looked it up this year, and it was, I want to say, don't let me quote it because I don't want to quote it wrong. But the last time I looked it up, most of our assets were under that. It did not create a taxable event. Trust, you don't worry about that. Yeah. So it did not create a taxable event because a lot of times what we don't want to do is create income for people. Yeah. But it did not create a taxable event. But I have to look up that amount because it changes annually. Okay. Okay, next slide. Lifetime transfers of property. The owner of property transfers, and this is usually in a real estate scenario, to an heir of beneficiary during their lifetime. The transfer must be in writing, usually evidenced by a deed. And of course, with any deeds, it's not valid until it's recorded. So a lot of times what I would do for individual clients as they were aging, a lot of my aging clients, we would do a life estate. We would transfer the property to, say, transfer my property to my daughter. However, I keep a life estate for myself. So that means for my natural life, I can continue to live in this property. And then you still have an interest in the property. The property cannot be sold without the knowledge and signatory of the life estate holder. But the life estate holder no longer owns this property. The property is owned by the person you transfer the property to. Taxes are based upon if the person who lives in the house, so she asks who pays the property taxes. Some of us are exempt from property taxes based upon age and income. As long as you continue to live in that property, you would still, life estate holder determines property status, property tax status. But you have to annually certify that every year that you still live in that property. So that can be an estate planning tool to keep from property being taken if you need estate benefits. I think we have a question back here.
I just want to make sure I'm clear with reference to rental property and your current home that you live in. I leave my rental property in a trust, right?
Yes, ma'am.
But I don't put my current residency in the trust until I pass, but I just put that in a will.
So say for instance, so she's going back to the trust instrument. So, because I want to make sure nobody's cloudy. What she's basically saying, if I own income producing property or rental property, my suggestion would be to put that property in the trust if you have a trust instrument. If you have your own home where you live in, you own it, you have a deed, I would recommend that that property remain outside of the trust, but that you have a will that transfers that property to the trust upon your death. That way, I want you to continue to receive any benefit that you receive from your property. If you receive homestead exemption, if you receive, the income on your taxes, if you receive that, I want you to continue to receive those benefits. If the trust owns it, you cannot receive those benefits. Okay? Yes, ma'am. Okay, yeah. I knew it was a lot because the last time he said it's 14 million. So it creates a taxable event if it's in excess of 14 million. And so that's why I didn't want to quote it, because annually it changes. Okay. But okay, so going back, I want to explain the life estate to you all. And so my mom's in the room, so I'm going to pick on her, okay? My mom transfers her house to me, okay? But when she transfers it to me, she keeps a life estate for herself. And so I cannot do anything to that property. I can't sell it. She still has an interest in that property. We're still tied at the hip. Once my mom passes away, I own it. Still, the life estate extinguishes, okay? So in the interim, if my mom needs to go to a nursing home or needs any kind of benefits, as long as it clears, I believe it's 7 years still, 7 years. Has to clear 7 years. They cannot say she owns that property. They cannot come in and do anything as far as benefits related to that property. That is the reason why we do it, okay? It's just a tip and a trick that we do to maintain property, okay? So what I found is that a lot of people, they had property, they needed state benefits, they were going to a nursing home. Nursing home care, we're not talking about a Cadillac nursing home. We're talking about, a civic nursing home. At a minimum, you're looking at $4,000 to $5,000 a month. a lot of properties, they had liens on the property that were more than the value of the property by the time their relative passed away. So that is the reason why we look at ways to transfer property so that you still have the benefit of it, but you're not the owner of it. Okay? Yes.
Transfer your deed to yourself. What if that person that you transfer to dies before the person has life
Okay, so I'm going to make what she says. So what I'm going to say makes it easier, and that's more complicated. I haven't seen, but what she's in essence saying is that I own my mom's property. She has a life estate interest in it. I pass away. I predeceased my mom. So then I would think at that time the estate would be transitioned by my will. By my will. Yeah, by my will. Not my mom's will. It would still recognize that life estate because that life estate is recorded. That's the purpose of it being in a deed, is recorded. So even if it goes to my heirs, that life estate is still there. Okay? I do have a will. I'm 19. I have a will. So state of Alabama plan. Remember, there's two plans. Yeah. If I pass away, the scenario is I pass away and I don't have a will. State of Alabama plan. Okay. Yeah.
I'm in a situation like that. Well, not no more, but my grandmama deeded her house to my mom, living deed. And when she died, my mom died before her.
Okay.
So she didn't go up there to transfer it. So by me being my mama's only heir, I received the house.
So I think what you're saying is that let's talk about that because I don't want to confuse anybody. Okay. I saw one more hand. Yes.
When you were talking about I guess you call it the living, where let's say I own property and I leave and I put the deed in my child's name, and you said something about, but it has to get past the 7 years.
Yeah. So if a lot of times what people will do, and so if you need to apply for Alabama Medicaid to assist you with nursing home care, they do an evaluation of everything that you own. They want to know how much assets you have. Do you have any resources? They want you to use your own resources to pay for any long-term care before state benefits are used. And they evaluate everything that you own. And so a lot of times what happens is people own real estate and that's the only thing that they own. So sometimes they will make people sell that property to pay for nursing home care before they will permit you to use state benefits. So what we're trying to do is think of a way that continues that property in your family, but allows you to access those benefits. So and I apologize if I didn't explain that well, but that's what we're looking at. Okay.
If my mother has a house and she decides to sell it, and then 2 years later she goes into the nursing home, does she just have to show accountability for the money she got?
Oh, that's income. They're going to look at it because they're going to look at selling that property. That would be income that she has access to.
She just has accountability.
Yes. So that would be income. Okay, one more question. We'll move on.
I'm sorry. So when my grandfather passed, there was no will or trust, and there's a home that's paid for. I guess it goes to my grandmother.
Look at the deed.
Okay, would it have to have her name on the deed?
It would. And it would need to say to husband and wife and to the survivor of them.
So if her name is on the deed, should we put her home in a trust? Because my mother passed and another aunt passed and there's one child left, and she doesn't help with anything, so.
I would evaluate it. to look at whether you put it in a trust, whether you retain ownership of it, and how you retain ownership of it. That's a method to do so. So it's just one way of looking at things. You know, do you put it in a trust? Do you, since she's not living in it, you can't do a life estate. So it's something to evaluate. Okay. Okay, we're moving on, y'all. Okay, let's go. Okay, life insurance policies, real quick. Life insurance policies. I talked about this earlier. Make sure you have enough life insurance policies. If you're going to use a life insurance policy for burial, make sure you communicate that to your family so they know where it is. Life insurance policies are income replacement. So you want to make sure you have enough. Husband and wives, you want to make sure that you have enough to cover bills to sustain your lifestyle. But proceeds from life insurance policies, they transfer based upon who is named as the beneficiary. There's no wiggle room in there. It's a contractual relationship. But I want to make sure that everybody knows where your policies are. If you plan to use it for burial, that you communicate that to someone. And also that you know who the beneficiaries are, okay? Okay, next slide. Okay, durable power of attorney. So we've talked about wills. We've talked about passing away with a will. We've talked about passing away without a will. Here I want to talk about some durable power of attorneys and what their purpose, what the purpose of these documents are, and to make sure that you have one. Next slide. So facts about a power of attorneys. A power of attorney lets you give someone else that power to act for you. The principal is the one who gives the power. The agent or the attorney, in fact, is the person who acts on behalf of the principal. So that's the general relationship. Next slide. This power doesn't give up your own authority. You can revoke it at any time as long as you are competent to do so. You can give a general power of attorney. I give A can do anything on P's behalf. Agent can do anything on principal's behalf, or A can sell principal's house. We generally do them with the real estate. We give them the authority to act on our behalf. That's a specific power of attorney. Next slide. You can, they can become effective when signed, or they can become effective. They can spring into effect based upon a later date. And usually that date is when a doctor determines that you are incapacitated. I always encourage people to have a primary power of attorney written in a document and a secondary power of attorney written in a document, okay? I had a client, her son was her power of attorney. He did everything for her. Son went to sleep, passed away. Guess what? We needed a secondary. So I always encourage people to have a primary and a secondary. Next slide. Make sure it's durable. Make sure you see language in your power of attorneys that say it is a durable power of attorney, meaning that it will remain in effect. Okay, so we were talking about durable power of attorneys. Remember, agent can give the principal. Agent acts on behalf of the principal. Those durable power of attorneys can be general, or they can be specific. Okay. Now, I used to hear this all the time, and I had to make sure that I explained to people, if someone has a durable power of attorney, you have designated someone to act on your behalf. Or I'm going to give you another scenario. Tell me your name. Okay, Andrea has durable power of attorney to act on behalf of her grandmother. And then grandmother passes away. The durable power of attorney is no longer valid once the principal passes away. So people used to call me all the time and say, oh, I have durable power of attorney for my grandmother, and they were trying to transact business. That document is no longer valid once somebody passes away, okay? So you need to make sure, if you're over the age of 19, that you have a durable power of attorney. So everybody remembers situation. Whitney Houston passed away, and she had a daughter. Everybody remember Bobby Christina? Bobby Christina was alive for several months, but she was incapacitated. Someone needed to be designated on her behalf to transact business, because guess what? She was a millionaire. She probably had bills. She probably had home. You got to have someone. So that's why I'm encouraging you all over the age of 19. People don't pass away in the same order that they used to. We learned that in COVID. Young people are passing away, predeceasing their parents, But there can be circumstances where you are alive, but somebody needs to transact business on your behalf, okay? Okay. Everybody get that? 19, get somebody, designate a power of attorney. Yes, ma'am.
Is it the same thing when someone is in the hospital as well? So, like last year, my mother had a stroke, and I have two older brothers, but everything went on me to do everything, like her bills and stuff like that. But when it came down to like being asked, are you the power of attorney for her and stuff like that, I had to say no because I didn't know.
So her question, we see it play out all the time. She said her mom had a stroke. She has 3 siblings, but she kind of took the lead role. So did your mom have a power of attorney? Sounds like she did not. And so what happens is, if you don't have a power of attorney, people are engaging with you. Third parties are engaging with you. They are engaging. They can give you information if they want to, but they don't have to. Most people will not give that information to you because they're charged with upholding privacy. So that's why it's so important that I talk about making sure you have the credentials in place. Not, like I said, this is a weighty topic. Nobody wants to do this, but it's just giving your family members or whomever you trust the authority and the documentation to line up with that. Okay. Okay. Any other questions? Yes.
As far as when you have a POA and the principal your POA has to be written. It's usually notified.
Notarized.
Notarized. Can the principal orally say, okay, I want you to do it
In writing.
No,
If
orally, can they do it orally?
in writing.
If they're
In writing. So all of these if you're revoking a power of attorney, it needs to be revoked in writing. Okay. Next slide. I got another question back there. Where are we going?
Is there an expiration on the power of
So
attorney?
generally, no, unless it's a specific specific power of attorney. Generally, the durable power of attorneys, there's no expiration, but it does expire once somebody passes away. So generally, no. The other thing I want to make sure is that you talk to your financial bank to see what is their policy on durable power of attorneys. Some banks have just been burned. Some will not take them. So we had a bank here locally. It was the general rule of the bank. They did not accept them. they did not accept them until he had an incapacitated parent and he realized he couldn't transact any business and he changed. So talk to your bank. Say, hey, what is your policy on taking a durable power of attorney? Because some of them are gun shy about them. I always mention this. So say, for instance, you don't have a durable power of attorney in place and you know, your doctors won't talk to you, financial institutions won't talk to you. What do you need to do? There is a court-appointed process where you appoint a guardian or a conservator for that role, okay? So I'll talk about the healthcare one, and I'll just, I think we're going there. We're getting there soon. I'll talk about the difference for it, okay? Next slide. Okay, advanced healthcare directives are also talked about as living wills, and I was glad and encouraged to see so many of you had those. It's a written document that allows you to decide ahead of time if you are permanently incapacitated or if you are permanently unconscious. Would you like food, artificial food and hydration? Or would you like to stay on life-sustaining treatment in the event that it would keep you alive, but it would not cure you? You can decide this ahead of time. It is a state form. You can go online. You can download the form. It requires 2 witnesses, and you can initial yes or no. Would I like artificial food and hydration? Yes or no. Would I like life-sustaining treatment under a circumstance where a doctor and a confirming doctor have determined that I can no longer think, feel, or know that I'm alive. And so let me tell you how this plays out. I think it's a great gift to give to your family members because, you know, some people will take medical advice and they'll say, yes, you know, I agree with what the doctor says, but you might have a holdout. And, you know, somebody would say, no, I want mama to be here. I don't want to take mama off. You know, it allows your mom to decide ahead of time what she would want to happen. So it breaks the tie, you know, if you have a deadlock on this. So I think this is a valuable tool to give to your family members. You can do this outside of a legal office. There is a state form that you can download. Have the relatives. The relatives cannot be related to you by blood or by marriage. Sign this and put it on file at your doctor's office. If you have a surgery, take it when you have a surgery, okay? Next slide. And I've gone through this. We can go to the next slide. Okay, so I talked about a durable power of attorney for healthcare. Now, this is a preference of mine. So the first thing I talked about was a durable power of attorney that dealt with business transactions. This one deals specifically with healthcare. As a practitioner, I separate mine because some people are good with making health decisions, but they may not be good with financial decisions and vice versa. If you find one person who is good in both scenarios, great, go with it. But if you find people that are better with healthcare decisions, like I used to have some clients. I had one lady, she was great. She would come to see me like every 2 years. We would change stuff. But she was very dug in that she had a daughter who was a nurse. And she said, hey, I want my daughter who's a nurse to make my healthcare decisions if I can't make them. But she said, my daughter who's a nurse, she got a nosy husband and he'll be managing my finances. She didn't want him in her finances. So I tend to split mine. But you may go to a lawyer and they may not split them. That's okay. But if you want to split it, at least you know that you can do that. You can say, hey, for my healthcare decisions, I want XYZ. For my other decisions, I want ABC. Okay? Let's see, next slide. Okay, we got to the part that I like. This is just testing your knowledge. And to do this, go to the next slide. I am a 90s sitcom person, so with my scenarios here, I brought up The Cosby Show and I brought up A Different World. So I grew up, Thursday night, you didn't go anywhere, you watched these 2 shows. So keep all of this in mind, and this will help you as you remember. Next slide. Okay, Cliff and Claire a young married couple, have a daughter, Sandra. Whitley and Dwayne, a young unmarried couple, have a daughter named after her roommate, Kimmy. So keep those in mind. I've changed the facts a little bit, okay? Okay, next slide. So the difference here, Cliff and Claire, they're married. Paternity is established for Theo or Sandra. Cliff's name is on the birth certificate. Parents are legally tied to the child. In the other scenario, you have Dwayne and Whitley. They are unmarried. Paternity is not legally established. Dwayne's name may or may not be on the birth certificate. Kimmy may or may not have his last name. This stuff is really important. When we talk about estate plans, don't wait till somebody dies to make sure that birth certificates and legal documents are in order, okay? So if people have children and they're not married, so if you have a child, you're married, the presumption is that that child is your husband's last name, husband, all of that stuff. But on the other end, you have a child, you're not married, so help your cousins out. They have children, make sure they're on those birth certificates, that they are legally established to that child, okay? Because this stuff happens. And when somebody dies, it might be too late to establish all of these things. Okay, next slide. So what should Dwayne do? He should sign the affidavit of paternity, placing his name on the child's birth certificate. He should file a petition to establish paternity. This is legally acknowledging the child. And then file a petition for the name change. So a lot of times, some kids don't go in their father's surname. But if you have cousins, put them in those surnames as quickly as possible, okay? Just don't call people Cooper, thinking, oh, that's Ted Cooper's child. And, they call people, and then the birth certificate has a different name. Because we see that. That's hard to change when somebody dies, okay? Okay, next slide. So Cliff and Claire purchased their first home, a brownstone in Brooklyn, New York. Next. So estate planning housing, they purchased a home. They have mortgage payments and they have a deed. So I'm going to tell you this. I don't get involved with what people do in their household, but if they're on the mortgage, they need to be on the deed. And if they're on the deed, they need to be on the mortgage, okay? So make sure your documents line up. Because your mortgage, what pays for the house, right? Your deed shows ownership. If you're paying for something but you don't have ownership, you are out of luck. You got to go through another process. So make sure you're on both of them. Next slide. Okay. Again, make sure the deed has joint tenancy with right of survivorship language. To Cliff and Claire, a married couple, as joint tenants with a right of survivorship. Effective this language, when Cliff dies, house goes automatically to Claire. House passes outside of the probate process, and that's what we want, okay? Next slide. Other non-probate transfers, what do we say? Joint bank accounts, put them on those bank accounts, or paid on death beneficiaries. Make sure we have life insurance with everybody's names, and we can also do a living trust, okay? So all of our married folks in the room, I would encourage you to have all of these things lining up. Next slide. Cliff and Claire now have 5 children. What else can they do to ensure that their children are provided for? What else can they do, y'all? What else? Yeah, so make sure their kids are listed. Make sure they have a will. What else? Insurance, all of that stuff. Make sure all those people are listed. So let's see what it says. Go. Okay, draft a will designating their property, how it's distributed at death. Designate a personal representative. Appoint a guardian to take care of their children. Any children under 19, you need a guardian for them. They can also create a trust for their children's care and their college education, okay? So these are things that are a part of your estate plan. Next slide. Whitley and Dwayne eventually marry. Dwayne dies, and Whitley has to deal with several issues, y'all. Let's go. Okay. And see, I got your answers up here, but Dwayne had life insurance. Dwayne forgot to change the life insurance beneficiary to Whitley once he died. His mother, Mrs. Wayne, is the beneficiary. Can his mother keep all the money? Yes. Why? Named person gets proceeds regardless of relationship. It's not fair, but it's legal, y'all. Okay. Next slide. Well, she can try. That's a statutory thing. She can come in as an omitted spouse. Yeah. You listening over here. That's right. Okay. Whitley and Dwayne had no joint bank accounts. Can Whitley get access to the money without a court order? No, no. How can she get the funds? She got to probate his estate, y'all. Okay. Yes. Well, he would have had to name her as the paid on death beneficiary. Yeah, yeah, yeah. But y'all listening, I'm good. Good job, cousins. Okay, come on, next. Dwayne's name was never added to Kim's birth certificate. Can Kimmy receive Social Security benefits from Dwayne? You got to prove it. You got to prove it. You got to prove it. So probably not unless you can prove it. It's hard. It's hard. You got to prove it, y'all. Yeah, you got to prove it. Okay, let's go on. Dwayne's mother has been acting strangely. She has not been taking her prescribed mental health medication. Whitley is concerned that she may hurt herself. What should Dwayne, and this should just be Whitley, do? You can file in probate court, you can file a commitment proceeding for any relatives that you believe are a danger to yourself or to others. If found in danger to themselves or to others, they can be committed to the State Department of Mental Health. Here, our Huntsville Hospital, they have a State Department of Mental Health designation at Huntsville Hospital. So it's not like people have to go to facilities like in Tuscaloosa and places that they used to. But I bring this up because all of us have relatives. They have mental illness. Don't leave your relatives on the street. Don't leave them subjected to the police system. You know, there are procedures in place to get them help if they are a danger to themselves or to others, okay? Next slide. While Mrs. Wayne is in the state mental hospital, Whitley tries to handle her business affairs. No one will talk to her. Mrs. Wayne's doctors also will not discuss her medical process. What should she do? She would have to file a petition for conservatorship in the probate court. A conservator is a person appointed by a court to manage the affairs of one who is legally incapable. Once appointed by the court, Whitley will have the authority to speak to third parties. So you have to remember a conservatorship or a guardianship are court appointments. But you can get around that by how? Durable power of attorney. Durable power of attorney. Yes. So conservator deals with finance. That's a financial process. A guardian deals with the person itself, deals with taking care of their needs, where they live, talking to their doctors. Does that mean the money that the mother got, Whitney can now use it to take care of? I don't know. Probably so. But what I'm saying to all of that is you can get around that by just having durable power of attorneys in place. Okay. Next slide. I think it speaks to that. Yes, file a petition for guardianship. A guardian is a person who has the legal responsibility to care for the individual's care, maintenance, and personal needs. And then once she's appointed, she can talk about her health care needs. Next slide. What should Mrs. Wayne have done? Signed a durable power of attorney, and we talked about that. Let's see, next slide. Is anything else? Okay, Cliff and Claire divorce. Okay, so I'm sorry, y'all. Cliff and Claire divorce. What should they do to plan for the future? And the answer is draft a new will changing gifts and responsibilities for former spouses. Remove former spouses' names from deeds to property, titles to vehicles, life insurance policies, bank accounts, and then sign a new durable power of attorney. Okay, next slide. Okay. I think we did questions all the way through. Do you all have any more questions?
I know you mentioned about the durable power of attorney expires when a person passes.
Mm-hmm.
What is in place after you have to speak to someone?
So nothing unless you have a will. You got to probate that will, or you got to go through the probate process, like they passed away without a will, the intestate process. And that gives you your formal credentials to talk and handle their affairs. Yes, sir.
Can PODs be put on a business account?
Talk to your bank. Talk to your bank about that. You may be able to. I think you can. It depends on the bank. I do know that. Because some banks were not doing it, but then some are. So talk to the bank.
When you were talking about the mortgage and the deed, when you were saying make sure that you are on the deed and the mortgage and opposite, okay, what if you're just doing the mortgage, but your spouse is on the deed? How does that affect? I mean, what?
So the reason why and this is just my practice corner, because I would see people, they would be on the deed, but when the payer died, the mortgage company wouldn't talk to them. And so you had to get the estate probated to get the credentials for the mortgage company to talk to you. And so that was my experience more than once. So that's why I just always said have the credentials, even if the qualification for the mortgage is in one spouse's name, it's just easier because you just don't want to have to get court credentials to talk to people. Because some people are gun shy, they won't talk to you. The other thing I want to tell everybody, and I mentioned this loosely, go home, find all of your important papers, put them in a central location, put them in a so a lot of people have fireproof safes at home. I'm a proponent of a fireproof safe at home as opposed to a safety deposit box in a bank. With a safety deposit box in a bank, there's nothing wrong with them, but you're subject to bank hours to get that documentation. I knew a lady, she passed away over Thanksgiving, so we had to wait for a court order because she was the only person on that safety deposit box. We had to get a court order to get open the safety deposit box, and that's where she kept all her life insurance policies and all of that kind of stuff. So we had to wait to bury her because we didn't have all of that information. If you use a safety deposit box, go and make copies of everything in it so somebody can know, where it is and what it is, or put somebody else on that safety deposit box. But no one person should just be on that box. So I'm a proponent for a fireproof safe at home. Okay. Yes.
To Attorney Conley, I am so glad Shauna and DST came up with this idea. I just went through, my mother passed, but thankfully I'm looking at it as a blessing. She was sick for 20 years. So I learned by experience, what you don't want to do, you have the opportunity to go get that taken care of. Because you take her to the doctor. They won't talk to you. They'll only talk to her, and she had a stroke, and this is so important. People that look like us, we need to really be about this business. Because when you're in the grieving process, or you know your loved one is dying, it is very difficult to think straight. And if you don't have all this stuff in order, they don't care. I'm sorry, you've been taking care of them. No, you can't access their bank account. Luckily, I was able to get all of this in order, but we need to start doing it like sitting there taking care of your family all this time. Somebody else will swoop in. She still has 7 or 8 siblings. Okay, what have you done? Luckily, I had already taken care of all of that. So you don't want to be on the short end of the stick or left out. And this is so important. I wish the church was standing room only because this is a serious matter. So thank you.
Well, let's give it up to our cousin over here. Yes, ma'am.
What did you say about, could we have more than one person individual?
Yeah, so you're going to designate a primary person. I do not recommend designating 2 people because they got to agree. So I say a primary and a secondary. I have seen people do 2. And, how do you break the tie? So I believe in a primary and a secondary. If you well, just do those 2. Just do those 2. And you know your children. You No. So okay, so she said she got 3 kids. The 2 will be okay, but 1 won't. If you just do not, if you think, hey, they all work together, you can do 2, you can do 3. But that outlier, the one who gonna cause a ruckus, don't put them. Don't put them. But tell them why. Tell them why. Okay. Okay.
So I have a
Wait,
question.
let me get somebody. Yeah.
So if you have, you did pre-burial plan.
Okay.
And you paid for your plot and everything. Fast forward years later, you got the deed. Is that considered land? Is that a land deed?
It is. And a lot of people, I hate to say this, but make sure, just check on that every so often. Sometimes,
So I have a question on that. Too.
Yes, a lot of, and we can talk about it after, but a lot of cemeteries sometimes go out of business. Or you would have dealt with somebody, change ownership. So make sure you check on that.
So what if somebody is buried in your land?
So let's talk about that. But it is, if you own a cemetery plot, that is an ownership interest. So make sure you keep those papers and keep those credentials. But make sure you make sure that the place is still open and, that you can still get in touch with people. So a lot of them just change ownership. And so if you don't have that documentation, if you don't sing, they're not going to holler. They'll sell stuff. So be very careful with that. You had a question.
Yes. So if I wanted to reach out to you to handle my grandmother's estate plan,
I got some.
how can I go that? I already have somebody that looks like you help me because I have no idea what I'm doing.
So what I have done, if you go to the next slide, I did some recommendations for you all. And it's just that it's not that I don't like doing this work anymore. It's just a time thing. I don't have the time. I'm no longer in private practice. So Top of Alabama Regional Council of Government, if you are 60 and older, they will do a simple will for you for free. And so tell your relatives about this. Now, there's a waiting list, but if you don't have any urgency, they will do a will for you for free. And so I recommend them. They have some other great services that they provide, healthcare services that they provide, prescription services that they provide. So this is a good recommendation for you. The next slide, I recommended some attorneys here in the area. Kimberly Brown, she's a member, both of these are members of Delta Sigma Theta. They're female attorneys. They practice before the probate court. I did not recommend anybody to you that I would not go to myself. Gail Williams and I, we worked together. We shared office space for several years. And so I think this would be good because they know how to interact with the court system. They've seen as much as I have. Yes, sir. I did. Oh, you're welcome. You're welcome. Yeah. And let's see what else. Did I have anything else? One more. Okay. For somebody mentioned air property, Alabama A&M through Cooperative Extension will be doing a workshop on air property on November the 11th. It is Veterans Day. It's free of charge. They'll do an information session, and then they'll have attorneys available who will work with you on your air property. So if you got property that is clogged up, you want to have ownership, this is a free service, y'all. So if you know anybody, share it with your churches. Registration open on September the 15th, and I heard that they're still not full, so there's still some slots available. If you know anybody, this will be great, a great opportunity. Yes. So they have the website on there. So try to take a picture of it with your phone, and then you can email so that they can have the pre-registration information. But this is a good opportunity to get some free legal advice, okay, on air property. And while you all are doing that, I just want to thank you all for coming out, using time of your Sunday where you could be watching football, laid on the couch, sleep, all of those good things. And so I just want to thank you all for coming to learn about this information. Please, again, do not wait until there's a crisis to set up your estate plan. Make sure that you do it and take care of all of these things in a timely manner. Take care.
Thank you so much, Attorney Conley.
All right, I have a short commercial break because this presentation was co-sponsored with the North Alabama Black Realtors Association. I am Sandra Brazelton, the longest standing member. So I just want to give you a 1-minute overview of NABRA because we are realtists. Everything that we own comes from the land, right? It was against the law for black people to read, write, vote, marry, or own property. This is our illustrious president of NABRA. Not only could we not buy it, we could not sell it either. The National Association of Realtors, NAR, was founded in 1908 but would not admit black members for decades. Their bylaws contained white-only clauses. Because of this systemic exclusion, an amount of wealth denied to African Americans in 1947, black brokers, appraisers, and agents gathered in Tampa, Florida to form their own organization, the National Association of Real Estate Brokers, NAREB. We are proudly called realtists, and our motto is democracy in housing. The purpose is to ensure equal housing opportunities, economic empowerment, and wealth creation in black Americans and other underserved communities. Through advocacy, education, and collaboration, NAREB works to eliminate barriers to home ownership, close the racial wealth gap, and protect property rights for all people. Today, the local chapter of the North Alabama Black Realtors Association, NABRA, continues that legacy, teaching families how to move from renting to ownership, how to protect their property through wills and probates, as we learned today, and how to build generational wealth that honors God and the sacrifices of our ancestors. We have a lot of work to do, and we invite anyone who shares our mission to join us. Our 30-year brokerage company, Qualitech Properties, is honored to be a founding member of this organization since 2003. So I want to challenge you and encourage you to intentionally spend your real estate dollar with realtors. Will all realtors please stand? NAREB is the oldest minority trade organization in the United States. For almost 80 years, our organization has been the boots on the ground, your voice and your advocate. We've been in our local schools and communities, educating and serving, teaching financial literacy, fighting against bad legislation, and fighting for our communities, hosting events like these with this great organization, and being the voice for the voiceless. When you invest in us, you invest in yourself. If you don't care who benefits from the billions of dollars that you spend in real estate, choose a realtist, because some of that money will stay in our community. If you do care about the billions that you spend in real estate, choose a realtist so we can work together to lift as we climb and fulfill the spiritual mandate of Proverbs 24:27, which states, put your outside fields in order. After that, build your house. Thank you, and I enjoyed the presentation.
Good evening, everyone.
My name is Alexis Tony. I'm the president of Huntsville Alumni Chapter of Delta Sigma Theta Sorority. I'd like to begin by thanking Dr. Ford and the Douglas Tabernacle Church family for allowing us to come here today to host this workshop with NAREB. Also like to thank Attorney Conley for imparting a wealth of knowledge to us this evening. And hopefully you learned a lot of information, and maybe you may have other questions for her at the end of this session. So really thank you for coming out and to sharing this information with us. Also like to thank our Economic Development Committee chairs. I'd like them to stand this evening. And the economic community. Also like to have the members of the Huntsville Alumni Chapter Delta Sigma Theta to stand so we can recognize you as well. Yes, yes. We've purchased 2 homes from Miss Sandra. So yeah, she's a great realtor. So realtist. So thank you all this evening for coming out.
Hello, my name is Sabrina Emmett, and I'm the president of the North Alabama Black Realtors Association. And this is just a great example of how collaborating really make it work. We're very proud to collaborate with Delta Sigma Theta, the Huntsville Alumni Chapter. I wear all these different hats, so I get confused who I am when I'm talking about we, they, who. But we're so excited. We just believe the information that was provided here today is very useful. And so many of us in our communities, we lack the knowledge. And our goal is to go around with churches and to provide great information that we can help advocate for housing and also build generational wealth. Now, I know y'all smell this wonderful food. So once we get finished, we're going to do that. But in the meantime, we have some door prizes. Who want to win a door prize? Anybody? Everybody? Okay. The one that came first.
Oh, that was Mr. Charles. What's his name? Charles Adams, I think.
Adams?
I think that's his name.
I think that's his name.
I think that's his name.
We always like to give a door prize to the first person that shows up. To me, that shows you're really committed. And so that person, I think, is Charles Adams. Okay. Let's say, I got to be Vanna too. Thank you. We appreciate your support. Okay. Okay. Got my number.
Okay, ticket number 999-3400. Come on now. Come on now.
Thank you. I'll take that.
And winners, stay here so we can take a picture with you after we release everyone, okay?
Let's see. Okay. I'm
Right,
ready.
the next. Okay. 999-3394. Come on now.
So I'm just like, I'm trying to walk out this. Thank you.
Thank you. Oh, where'd you get that from? Oh,
that's
oh,
it, yeah,
I got
yeah.
you. 999-3360.
Okay. Mix up and do some of these.
Right. 999-3364. Not bingo. She talking my language right there. Bingo. Right? 999-3390.
Oh, in the back.
Oh.
Yeah.
I'm shaking. Okay. Okay. Oh, we got the winner. Oh, want me to do it again?
999-3390. Okay. All right. 999-3369. That row over there doing good over there. Okay. 999-3381. Nine 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 3415.
Okay, so last two.
999-3383. Come on now.
Oh, she got. And the last one. Yep, this is the last one.
Last one. Nine 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 3377. It's my favorite number.
Oh.
It's my favorite number.
She's got one she wanted to
Oh, okay. And then we have another raffle.
So as a 30-year real estate broker and real estate instructor, we understand the challenges with generational wealth. Their property we can't list. I also teach it. You will not learn about this in real estate school. It's so important that we have these forums. My daughter and I co-sponsored Wills, Probate, and Real Estate, and it's just a way to put all your documentation together. We do have a lawyer who endorses and provided some information as well. So we want to give this away as a free door prize for you. We also have some resources on NAREB out in the lobby. See Sharita and Law. Let's just build this together, okay? All right. Oh. Who's lucky? Who's feeling lucky? They're in my trunk. They're $25. Cash App, Venmo, pay. Sell your products, sweetie. 999-3376. Really? They're $25. I get $10 for that ticket. Thank you.
Yeah.
Attorney Conley, would you come forward, please? And the Economic Development Committee, come on up. Those that are here. On behalf of the Huntsville Alumni Chapter of Delta Sigma Theta, the Economic Development Committee would like to give you a token of our appreciation. And please, please go to our website, which is dsthuntsville.org, for any future events that we have coming up. We have a lot of stuff for our children. We have a book, Children's Reading Hour. It's the first Saturday of each month. It's at the Cersei Center. And there's other events that we have. So we really would like for you to go to our website and check out any activities we may have. And come on out. We'd love for you all to be a part of our events. Thank you.
Okay, so now if y'all want to follow me over to the hall for this wonderful food I have prepared for us. Oh, we want the pictures with the winners. Okay, if you want a door prize, please come to the front so we can take a picture. Thank you.
And before you dismiss, again, Douglas Tabernacle would like to thank you, Delta Sigma Theta, and Soror Conley, on behalf of our pastor, Elder Ford. Don't know where he went, but on behalf of our pastor, Elder Ford, we appreciate you. And if there's anything we can do to assist you guys in the future, please feel free to contact us. Thank you.